IP strategies for software protection. Software drives innovation but is also a large source of exposure to risks. Software is vulnerable to copying, reverse engineering, employee leaks, and piracy. Software vendors lose nearly $46 billion annually to software piracy, which is why it is critical to think proactively about protecting your source code, algorithms, internal workflows and tools, and your overall competitive advantage. There are 4 primary ways to protect software, including copyright, patent, trade secrets, and contracts. Copyright can protect source and object code but cannot protect any functionality. Patents are able to protect the functional aspects of the software. Trade secrets are beneficial because they can protect any confidential information or technology that may be difficult to patent due to the current state of patent law. Lastly, contracts are another method of enforcing IP rights and licenses. Contracts control one's access, use, and distribution of the software. Because each type of protection has benefits and disadvantages, a comprehensive, multi-layered approach to software protection is best. By utilizing multiple methods at once, you can take steps to ensure your software is as protected as possible. Some aspects of software are eligible to be protected by copyright. A copyright protects original works of authorship fixed in a tangible medium. Computer programs are considered literary works and are therefore protected by copyright. Copyright protection is automatic once the code is written, but in order to enforce the protection, namely, to file a lawsuit, the copyright must be registered with the Copyright Office. Copyright protection gives the owner the right to prevent others from accessing, using, creating derivative works, and more. Major technology leaders have registered their software with the U.S. Copyright Office, including Amazon, Microsoft, Intel, Apple, and more. The primary limitation of protecting software with copyright is the lack of protection available for the underlying ideas or functions. Because the work must be fixed in a tangible medium, ideas and functions cannot be protected with copyright. Additionally, if a competitor recodes the same feature using different language, they are not necessarily infringing, which is why copyright alone is often not enough. Patents have historically been a prevalent method of software protection. One of the first prominent cases was State Street Bank and Trust versus Signature Financial Group, in which the court held that software and other processes that create a useful, concrete, and tangible result should be able to be patented. After the decision, the majority of software was considered patentable. In 2012, the Supreme Court heard Mayo versus Prometheus. The court's decision held that claims which contain a law of nature are only patentable if the claim applies the law of nature. In order to apply the natural law, the applicant must include additional elements to make the claim man-made. The most recent prominent case is Alice Corp. Versus CLS Bank International, in which the court established a 2-part test to determine if a software is patentable. The decision limited the number of applications for software that are patent eligible. The first part of the test asks if the idea is abstract and then asks if the patent claims add enough to be a practical application. If the software passes both steps, the patent offers protection for 20 years. Patents are more expensive to acquire, take time, require public disclosure, and have a limited time frame for protection. Additionally, even after the Alice decision, many software patents and applications are still rejected or invalidated for being abstract. Patents protect the functional aspects of software, unless the applicant decides to apply for a design patent. Design patents protect the ornamental aspects of a software. This is typically seen with graphical user interfaces, although any functional aspect of a GUI for which protection is sought must be through a utility patent. Factors to consider in deciding whether a patent is the right form of protection for you include whether the software is novel, non-obvious, and useful. Additionally, an applicant should determine if the software can fulfill the Alice test for patentability. Finally, because software can be protected through either design or utility patents, the applicant should determine what they are wanting to protect, the functional or ornamental aspects. For many companies, trade secret protection can be more practical, especially for tools like proprietary algorithms or tools and information you do not wish to disclose in a patent application. Trade secrets can last indefinitely, but only if the company takes active steps to maintain its confidentiality. These steps include limiting access, marking materials as confidential, using NDAs and internal policies, and more. Once a trade secret becomes public, whether by breach or accident, the protection vanishes. While protecting software via trade secrets avoids the cost and exposure of a patent, operational discipline and risk of theft and independent development are factors to consider when relying on trade secret protection. Contract law enables the enforcement of IP rights. Each time a company licenses software, onboards a developer, or works with a third-party vendor, the contract sets the terms of engagement and use. These documents control what the user can do, whether the code can be reverse engineered, and who owns the resulting IP. Contracts come in many forms for IP protection. For example, non-disclosure agreements and non-competes are important for protecting trade secrets, especially when working with external collaborators. Additionally, IP assignments are common in software development. IP assignments ensure that anything created by the developers while working for a company is owned by the company and not the individual. Finally, source code licenses and source code escrow agreements are other methods of using contracts for software protection. These agreements place the source code in the possession of a neutral third party and sets conditions under which it can be released. On top of the examples mentioned, there are many other ways to protect software. Contracts give a company flexibility. Contract terms can be tailored to a specific product, risk profile, and business goal. The different types of protection are able to work together to create the most comprehensive plan possible. Copyright is relatively fast, inexpensive, and automatic, which makes it an essential foundation for protection. Copyright protects the actual code written by developers but does not protect functionality. Copyright protection only stops someone from copying the code as written. If a competitor recreates the same functionality using different code, copyright will not be helpful. Patents, by contrast, protect what the software does, the underlying methods, systems, or processes. The benefit of a patent is broad exclusivity. If a company holds a valid software patent, the company can prevent others from using that idea regardless of the coding of a competitor. But patents have higher costs, can take time, and require public disclosure. Trade secret protection is especially helpful for client lists, proprietary algorithms, machine learning models, or internal tools that a company may want to avoid publishing. Trade secrets require no registration or filing. The only, but vulnerable, requirement is that the information is kept secret. Trade secret protection often occurs through internal access controls, employee NDAs, and consistent marking and handling of confidential material. If a company loses control of the information is no longer protected. Finally, contracts allow one to define and enforce the rights on their terms. A contract can determine who owns the IP, who can access what information, and what happens if there is a breach. There are many types of contracts that can be helpful to protect software. While any tool can be used by itself, together, the combination of the tools can create a robust IP framework to protect your software.